The police used force to extract the confession, and that made the confession inadmissible. So the confession will not form a part of this case.
That was the ruling handed down by Belmopan Supreme Court Justice Antoinette Moore today in the voir dire of the murder trial against William Danny Mason and 4 co-accused men. In the minute trial within the trial, the prosecution in the form of DPP herself, Sherilyn Vidal, attempted to get the judge to include a caution statement by Ernest Castillo as a key evidence in the trial. In that statement, Castillo confesses to the murder of Pastor Llewellyn Lucas back in July of 2016. But legal aide Baha Schumann, who appeared on behalf of Castillo, was able to convince the judge that the statement was given under duress and it is now excluded from the trial, and details cannot be referenced in the arguments going forward. Now, it is believed that if the statement was accepted, Castillo would have essentially taken the rap for the killing, and as such, the murder charge against Mason, Terrence and Kieran Fernandez, as well as Ashton Venegas, would have been disposed of. But since that did not happen, what does that mean for the defense attorneys?
Never did mean anything for my case, but I think it is significant for Miss Baha Schumann. She was a person who really did all the work, and she needs to be commended for the work that she did. And I think that now that it's not included in the case, it cannot be used as evidence against her client. So that's what.
If it was admitted in as evidence, it would have been a key piece of document or information for you as the defense attorney for co-accused. Talk to us about that, what you can share.
When witnesses speculate in court, I get on them, so I don't want to speculate. It's not in evidence. I can't speculate on what would have happened had it been included in evidence. It's really a dead issue as far as this case.
It could have been used as, you know what, this man is taking the blame, so it would exonerate your client.
That is not the case.
Guyanese attorney Dexter Todd says that every statement given by a suspect in a matter must be freely and voluntarily given. He says Castillo's caution statement had no effect on his client.
There was no direct effect of that caution statement to my client. I believe the law is still trite on the issues that a caution statement can only be used allegedly by the maker of that statement and would have never really affected any other person. All right? It cannot affect any other person. It is only acts to affect the maker. All right? But I don't believe it's an issue anymore because I believe the court has given a very sound ruling on it, and the court has given very sound reasons why the court would exclude that statement.
Around 1:30 this afternoon, the 5 accused men, shackled in cuffs at the hands and feet, were escorted down the steps of the court building and placed into a police van. They were taken under heavy police guard back to the central prison in Hattieville until July 22nd, when they are to reappear in court, this time at the Supreme Courtroom of Justice Williams in Belize City. The substantive murder trial continues with the testimony of witnesses. Attorney Brian Neal explains the change in venue.
On Monday, we will be in Belize City because some of the witnesses will testify over the Skype technology. So we will be in Belize City all of next week, and I anticipate possibly the week after. So maybe 2 more weeks, and we can have some resolution as far as I can see. My defense will not be very long. The strategy really for me is to try to absolve my client. He has pleaded not guilty, so he is saying that he is not in any way associated with this crime. And it is to try to make sure that if the prosecution does not prove that he was involved, that he is entitled to an acquittal. So that is my strategy going forward.
Over a dozen witnesses have already been called since the trial commenced in March of this year. And even though there were several delays and many more witnesses to testify, Todd says that he believes that the case will soon wrap up.
There are witnesses that went, yes, but they are not with some of the witnesses did not speak to any essential element of the offense. And therefore, there is no need for me to recall some of those witnesses to waste and delay time. I believe what we have at the latter part of this case is really the evidence to be considered as against the accused persons. I would not judge to say whether there's evidence, it's evidence of any credible weight. That is for the court to decide. But I would say that this latter part of the case is where the concentration must be heavily placed on.
While several defense attorneys have made applications to recall witnesses, Neal has made a request for a site visit during the trial. Dwayne Moody for News 5.